This is an application and appearance in the matter of F8 Holding, Moscow Limited and AO UniCredit Bank.
Yes, Mr. De Cruz.
Morning, my lord. I appear in this matter with Mr. Emil Simpson on behalf of the Appellant Fashion House Moscow Limited. Mr. Simpson will not be in attendance tomorrow due to another commitment. Clash has arisen because of the expedited nature of this appeal has required its listing without reference to counsel's availability. But Mr. Simpson was keen that I inform you, as a matter of courtesy, that he won't be here tomorrow and means no discourtesy, disrespect, if he isn't, when he isn't here tomorrow.
Yeah. Now, although the appeal was expedited, we have, of course, read the latest Russian judgment.
Yes.
And it seems that some of the urgency has gone away for the time being, at any rate.
Yes, it's now reached a stage whereby there is a 1 month period in which UniCredit may appeal.
Yes.
If it appeals, then it goes off to the appeal stage. Yeah, so that's where we're at the moment.
Yeah.
Moscow. Yes. The respondents are represented today by my learned friend, Miss Hutton, KC. In this appeal, I will be referring to UniCredit SPA as SPA and UniCredit AO simply as AO.
Right.
Before I go any further, can I just check with your lordships whether you intend to have a transcript break?
A what break?
A transcriber break.
No.
Thank you. So this appeal relates to the judgment of Mr. Justice Henshaw, dated 25th of November of last year.
I can just tell you that we've read the judgment.
Thank you.
We've read the skeleton arguments.
Thank you.
And as I've mentioned, we've read the decision in Moscow.
Thank you very much. So you will see, my lord, that in Mr. Justice Henshaw's judgment, in summary, he dismissed Fashion House's claim for antecedent injunction. He held it didn't breach the Moscow proceedings. He granted SPA's summary judgment application for the same reason, and also granted AO's application to set aside service out on the basis of his conclusion that the court didn't have jurisdiction to grant an antecedent injunction against AO. So we seek to set aside those aspects of his judgment, which are paragraphs 1 to 6 of his order. We also, my lord, as you will have picked up, wish to make, if relevant, a Latin Marshall application in respect of a short Russian language expert report submitted by Viktor Prokofiev, a Russian language expert. I don't know if your lordships have picked that up, but I'll give you the reference to it.
Yes, certainly we have.
You have, thank you. And your lordship will have picked up that my Lord Justice Mayles directed when granting permission that that issue be dealt with today. If that application is granted, your lordship will also have picked up that the respondents will seek to rely on their own expert report from Mr. Petikovsky. I will, with your lordship's permission, deal with the Latin Marshall application when I get to the relevant part of the appeal. That will provide a better context for why we say it's relevant. So with that, my lord, your lordship will also know that there are 4 grounds of appeal, and that the first one relates to our respectful submission that Mr. Justice Henshaw was wrong to hold that the Moscow proceedings are not in breach of the arbitration agreement. Our second ground of appeal is that we say he was in error in relation...
By the arbitration agreement, you mean the arbitration agreement in the facility agreement?
I do.
Not the one in the mortgage agreement?
Well, yes.
Not
so
dispute resolution clause, rather.
Exactly. So when I say arbitration clause, I do in fact I do absolutely mean the facilities agreement, because the dispute resolution clause in clause 21 of the mortgage agreement is not arbitration. It's a dispute resolution. So yes. When I refer to arbitration agreement during the course of this appeal, I am very much referring to clause 42 of the facilities agreement. The second ground of appeal you would have picked up, we say that the learned judge was in error to hold that the court didn't have jurisdiction against AO. And we, the first ground of argument that we had that was dismissed in respect of jurisdiction was the gateway under paragraph 3.16c of practice direction 6b. We call that in respect of a contract governed by English law. We'll come to the minutiae of that in due course. That's our second ground. Thirdly, we say his lordship was wrong to hold the court alternatively did not have jurisdiction under the necessary or proper party gateway as against AO. So that's paragraph 3.13 of Practice Direction 6B. And then our fourth ground of appeal is we respectfully submit that his lordship was mistaken in the legal approach adopted when holding that it would not in any event be just and convenient to grant an anti-suit injunction against SPA. Those are our four grounds of appeal. Lordship, you will have picked up that in the Moscow proceedings, AO sought to enforce against Fashion House's mortgaged asset on the basis of an alleged event of default as defined under the facilities agreement, namely an alleged failure to make payments said to be due under the facilities agreement. And Fashion House's position generally and in the Moscow proceedings was that there had been no such event of default for two reasons. The first being that the payment of sums due under the due to SPA under the facilities agreement were not currently payable as a result of Russia counter-sanctions law and the principle of foreign illegality, the English law principles of foreign illegality and the effect of that on the payment obligations. That was the first argument. The second argument is that the payments due to AO under the ruble facility, which arises under the facilities agreement, had been rescheduled as a result of an agreement between the parties in July 2024. And that was said to have given rise to an English law estoppel defense. So for both of those reasons, Fashion House's position is that no event of default in respect of non-payment had or variation, estoppel or variation, I'm reminded by Mr. Simpson. But as a result of that, no event of default had occurred. So Your Lordship have picked up the update in relation to the Moscow proceedings as a result of a judgment that was issued on the 19th of March. And we hope that the documents have found their way into Your Lordship's bundles. Our position, and you'll see from the letter that accompanied the Russian judgment, is that nevertheless, this appeal and the injunction that we seek is still very much relevant because it would bite on the right that UniCredit has to pursue the Moscow proceedings at an appellate level. And we say it is also very much relevant to the alternative scenario of AO pursuing, both on its behalf and on behalf of SPA, fresh proceedings for enforcement of the facilities agreement on the basis of an alleged event of default, in the event that it receives the necessary and currently absent approval from the Russian Central Bank. Your Lordship will have picked up that the reason why AO's claim was dismissed on the 19th was because no such approval had yet been obtained.
Yes.
For those reasons, we say this is still very much a live appeal.
So do you say that the Russian court has decided that the payments were illegal under Russian law?
No. What the Russian court decided was simply that the payments were due and owing under the facilities agreement, under specifically clause 23.1
Yes,
of the
indeed.
facilities agreement. As a result, it concluded that there'd been an event of default, and as a result, it concluded that in principle, and subject to approval from the central bank, there was a right to enforce.
No, I follow. Speaking for myself, I just have a difficulty with your reliance on an English principle that says that payment is due if the payment is unlawful under foreign law,
Yes.
where the foreign court has decided it's not unlawful.
Well, the reason why the foreign law, so the foreign court made the decision that it did
Hmm.
was completely absent the application of the principle of of foreign illegality, the Raleigh brothers.
I understand that, but isn't a necessary predicate of that defence that it is in fact illegal under foreign law? And if the foreign court has decided it's not, how does the defence work? Are we to is an English court to decide that, contrary to what the Russian court has said, it is after all illegal under Russian law? That seems a bit
Well,
odd to me.
the Russian court did not engage directly on the effect of the Russia counter-sanctions regulations. It just looked at the one narrow issue of whether or not, under the terms of clause 23.1, there had been an event of default. And so the question for your lordship is, was it entitled to make that decision?
I see.
Which is a matter of English law. So with that, I come now to ground one.
Yes.
If I may. Now, as your lordship will, we've already discussed, that the arbitration agreement forms part of the facility agreement. The basis of the judge's finding of non-breach was his conclusion that the issues in dispute in the Moscow proceedings that I've identified fell within the scope of both the arbitration agreement and the jurisdiction clause in the linked mortgage agreement, so the jurisdiction clause 21, and we'll come to these clauses in just a moment, which confers jurisdiction on the arbitration court of the city of Moscow. Now, the issue, therefore, is whether the judge was correct in his interpretation of the scope, as to the scope of the dispute resolution clauses, both in the arbitration agreement, but more specifically in the mortgage agreement.
Is that a question governed by English law or by Russian law?
By English law. The question is because the question.
The scope of clause 21 is governed by English law, is it, rather than Russian law?
No. But the issue is for your lordship is whether the Moscow proceedings were brought in breach of the arbitration agreement under the facilities agreement, which is governed by English law. Now, as a matter of English law principles, that requires looking at relevant linked agreements insofar as the facilities agreement is part of a suite of agreements, which there's no dispute about. So in order to decide whether or not UniCredit was entitled under the terms of the arbitration agreement to bring the Moscow proceedings, rather whether the Moscow proceedings were a breach of the arbitration agreement, it is necessary to look at other linked contracts, the jurisdiction clauses in those linked contracts, and whether the effect of those jurisdiction clauses casts a different complexion on the interpretation to be placed on the English law arbitration agreement.
Is the
So-
arbitration clause in the facility agreement governed by English law?
That's governed by Austrian law, but there's no dispute as to the meaning of the arbitration agreement, that it has a different meaning under Austrian law as it would under English law. But what we are dealing with here is whether or not your lordship has the power to grant an antecedent injunction and should grant an
So
antecedent
we are
injunction.
interpreting the combined effect of two dispute resolution clauses.
Yes.
One, a dispute resolution clause governed by Russian law.
Yes.
The other, an arbitration clause governed by Austrian law.
Yes.
And in order to decide the scope of those dispute resolution clauses, we are to apply English law.
Yeah. Well, your
Why?
well. Let me put the position in this way, and I think I might have misput the position in relation to the previous question. Your lordship is quite right that the arbitration agreement itself is governed by English law. It's part of the facilities agreement, which is governed by arbitration agreement is governed by Austrian law. It's part of the facilities agreement, which is governed by English law. The question for your lordships is whether applying English anti-suit injunction principles in those circumstances, your lordship should grant an anti-suit injunction to restrain what we say is a breach of the arbitration agreement. And in terms of interpreting the scope of the arbitration agreement, there is no difference between English law and Austrian law. For example, as to the meaning of arising out of or in connection with, that sort of thing. Nor is there any dispute specifically that that anything concerning an event of default, a dispute as to whether an event of default has occurred, falls within the arbitration agreement. In those circumstances, the question for your lordship is, should you use your powers to grant an anti-suit injunction to restrain a breach of that arbitration agreement?
Why do we assume that the principles relating to the grant of anti-suit injunctions are the same under Austrian law as under English law, when it's pretty much common knowledge that many jurisdictions in Europe take a very different view to the one that English law does?
We proceeded at stage below, before Mr. Justice Henshaw, on the common basis, on the common ground, that a dispute over the occurrence of an event of default fell within the arbitration agreement. There was no dispute that the fact that the arbitration agreement was governed by Austrian law rather than English law makes a difference. So, in relation to that narrow point, it was common ground. It is common ground that this issue is covered by the arbitration agreement. The question then of whether, in that context, this court can and should grant an anti-suit injunction, that is a matter of English law applying the principles in UniCredit and Rus-Gem Alliance, I should say. That's how we put the position.
Did the Russian court in its recent decision decide that the scope of clause 21 was wide enough to cover the disputes?
Shall we look at the Russian court decision?
I think it did. That's my reading.
There was a determination that there shouldn't be a stay of the proceedings because they were within the scope of the clause.
Yes, I don't want to mislead the court inadvertently, so it's best that we have a look at that.
No, I think
The translation only came in over the
the Russian judge did decide, as I understand it, that the clause 21 of the mortgage agreement was wide enough to encompass the dispute. And she said that there might be other kinds of dispute arising under the facility agreement which didn't involve enforcement of the security, such as getting a monetary award or whatever, which would be within the scope of the facility agreement arbitration clause, but the clause 21 was wide enough to encompass the dispute before the Moscow court.
Yes.
And that would be a Russian law question.
Well, that would be a Russian law question, but the question before your lordship is whether an anti-suit injunction should be granted because of a breach of the English. Because of the breach of the arbitration agreement.
In an English contract.
Yes, that's right.
We have to approach that question, do we, on the basis that the court, just able to apply the governing law as to the scope of clause 21, has held that clause 21 is wide enough to cover the present dispute. So you're asking us to decide that as a matter of English, I think you put it, principles of anti-suit injunctions, might be English questions of construction, the arbitration clause in the facilities agreement is exclusive in relation to the disputed items. When the Russian court, who is the court applying the appropriate law to clause 21, has held that the scope of clause 21 overlaps with it. How does that work?
Well, when In holding that clause 21 of the mortgage agreement applied to the scope of the dispute, the Russian court did not consider or apply the principles that we say should apply to the prior question of the arbitration agreement. And if those principles had been applied, then the correct conclusion is that the Moscow proceedings are in breach of that arbitration agreement. And that is the first question.
Why do you say it's a prior question? If you strip out which law you're applying, it's a choice between mutually exclusive scope and overlapping scope.
Yes.
Why is that a decision necessarily for one of the two courts applying their own system of law? And we know that they're governed by potentially both systems.
Well, because the question for your lordship is, and it will come to, it will take into account at least the analysis of clause 9. But the question for your lordship, first and foremost, and this is our position, is that in order to, the question for your lordship is whether or not the arbitration agreement has been breached. If the arbitration agreement has been breached, applying the principles that we rely on, the conclusion is, we respectfully submit, that your lordship should step in and grant an anti-suit injunction. Now, that is irrespective of the contrary view that the Russian courts may take, particularly in circumstances where they haven't analysed, we say, the proper principles that apply.
Can I just put it another way? There's not been much focus in the argument on what the meaning is of the arbitration agreement in the facilities agreement. The focus, when looking at whether there is mutual exclusivity, has been in construing the mortgage agreement, and
Yes.
particularly on clause 9.
Yes.
Now, the focus on those questions of construction are Russian law questions of construction, aren't they? And clause 9, what clause 9 means is governed by Russian law, isn't it?
Yes, but in there was some reference in the Russian judgment to clause 9, but there was no consideration about how clause 9 works alongside the arbitration agreement. And that is the question for your lordships to apply today.
I can't understand that. I'm just struggling why you say that is an English law question. How clause 9 works alongside the English law agreement depends on clause 9, doesn't it?
No, how clause 9 works depends on how clause 9 operates applying the BNP principles alongside the arbitration agreement. And that is an issue which was not considered by the Russian courts. Lord, would it assist you to go to the arbitration agreement and clause 21 of the mortgage agreement? It sounds as though your lordships have that well in hand, well to mind.
Well,
If
we've
not,
looked
I'll
at
move
them, but
straight
if
on
there are
to-
particular points you want to make on the detailed wording, then of course we'll look at them.
Let me just check. I don't think so. I think I will just make the preliminary points that, of course, the mortgage agreement and the facilities agreement, as your lordships will have picked up, are part of a very complex suite of agreements. We've calculated there are 13 categories of finance documents, as it were, that form part of this suite of agreements. So that's an important context to the principles we are going to look at in a moment. I'm just looking here to see what points I can omit. I think we can move straight on to the relevant principles, the BNP principles. Again, it seems to me that your lordships have that well in mind as well, but if it assists, I can take you to the exact passages in BNP which set out the six core principles.
Well, I don't think there's any dispute. The judge directed himself properly on those principles.
Yes.
Your complaint is he then misapplied them.
Yes, correct. And I should say that there was obviously there's no dispute that those principles were the correct principles to consider, the correct principles by which to analyse the critical question of whether or not the Moscow proceedings were in breach of the arbitration agreement, notwithstanding the fact, and I do take it into account, that the arbitration agreement itself is Austrian law. But we all proceeded on the basis that the proper way to approach that were the principles set out in BNP. And with that, my lord, I come to clause 9, because that was the foundation of the judge's analysis that the parties had legislated in clause 9 for a dispute over the occurrence of an event of default to fall, we say counterintuitively, within both the arbitration agreement and the mortgage agreement, clause 21. So if we turn to clause 9 itself, you will see, core bundle please, that it starts at page 183. And the first thing I would direct your lordship's attention to is that the whole of clause 9, that the heading of it is enforcement procedure. Then 9.1 talks about, as a heading, the right to enforce. And we say that that in itself, just pausing there, is relevant because it demonstrates that what clause 9 is seeking to do, and the only thing that clause 9 is, clause 9.1 I should say, is seeking to do, is to analyse or to set out how, when the right to enforce comes into force, and what is to happen after that right to enforce is triggered. That's all it is seeking to do. And specifically in clause 9.1.1, we see that it says they're subject to any other provisions of the agreement and or to the facility agreement. The parties agree that the occurrence of an event of default shall constitute a material breach of the secured obligations, giving rise, we say that's significant, the term giving rise, to the mortgagee's entitlement to levy execution of the mortgage property. At paragraph 57 of his judgment, for your reference, page 114 of the core bundle, his lordship found that this clause, 9.1.1, provides that execution can be levied by a judicial procedure as soon as an event of default has in fact occurred, as distinct from after a separate tribunal arbitral process has confirmed that to be the case. And we say, with respect, that that conclusion was wrong for the following reasons. We say that the purpose of clause 9.1.1 is only to identify the point at which the right to levy execution under the mortgage agreement comes into existence. That is to say, in terms, upon the occurrence of an event of default, as defined, not under the mortgage agreement, but under the facilities agreement. We respectfully submit that that purpose is plain from the natural meaning of the provision that an event of default is a material breach giving rise to the entitlement to levy execution. That is to say, no right to levy execution until that point. But what clause 9.1.1 does not do, and is not seeking to do, is to say anything about the prior issue of how a dispute as to whether an event of default has occurred is to be determined. It just doesn't engage in that point, that relevant point for our purposes. And the judges use the phrase as soon as, and in fact, they don't appear in clause 9.1.1. What it reveals, we respectfully submit, is that the judge treated an event of default incorrectly as a simple factual issue, which justified an immediate resort by AO to levy execution, to commence proceedings in Moscow.
Well, if this were an English mortgage secured on property in England,
Yes.
and the mortgagee says, I'm starting possession proceedings or foreclosure proceedings or whatever it is, because you, the borrower, have failed to pay what's due.
Yes.
And the borrower says, no, I haven't. I've paid everything that's due, or my payment obligation is suspended or whatever. The court would simply decide that. To split it into what you call a prior event and the process of enforcement strikes me as being really rather an artificial distinction. That is exactly the sort of dispute that you would expect to arise in enforcement proceedings.
Well, we say it with respect, would be wrong to cast or consider as an analogy a traditional mortgage agreement, because what we're dealing with here is a complex suite of agreements. One of 13, the facility agreement and the mortgage agreement are part of one of 13 agreements.
Well, a mortgage agreement is frequently given to secure obligations under a separate facility agreement.
Indeed, and then it's a question of what are the terms of the mortgage agreement and what are the terms of the linked finance agreement. So we say it will be wrong to draw any general conclusion, because ultimately, as in all these cases, it depends on the terms of the contract. And so we have to look, we submit, at the terms of the arbitration agreement alongside the terms of both clause 9 of the mortgage agreement and clause 21 of the mortgage agreement. It's a narrow exercise. It's that narrow exercise we're engaged in. So the judge, we say, wrongly treated this as a simple issue of fact, and the fact and that it is not a simple issue of fact, that the occurrence of an event of default is not a simple issue of fact, is readily apparent when one looks at the complexity of events of default that we are dealing with in this case. And they are set out at clause 23 of the facilities agreement. Your lordships will have picked up from our skeleton argument the point that we make, that there are 22 events of default set out in that clause 23, and that those 22 examples are set out over 4 pages, and they are very, very complex. They are very varied and they're very complex. And ultimately, therefore, and we'll come to this, I will ask your lordships to look at this in a little bit more detail just now, but ultimately that means that whether or not an event of default has occurred is a legal exercise. It's not a factual exercise. But can I just make good that point by asking your lordships quickly to look at clause 23, if I may? And your lordships will find it in the core bundle at 172, page 172. And what I ask your lordship, or I draw your lordship's attention to, is just, firstly, from an immediate cursory look at how this clause 23 is set out, the complexity of it and the detail of it, but also to make good the point as to the legal nature of what one is talking about in terms of events of default. I draw your lordship's attention to the legal concepts that many of these examples involve. So, for example, 23.3, other obligations, which refers to a transaction obliger that does not comply with any provision in the finance documents, which of course requires an legal analysis of whether or not there has been compliance with those myriad of finance documents, 13 categories. Then 23.4 misrepresentation, 23.6 insolvency, supported by 23.7 insolvency proceedings, 23.11 unlawfulness.
Is all this going to the submission that the parties wouldn't expect these kinds of questions to be determined by a Russian court because the Russian court wouldn't have the expertise in English law? Is that where this goes?
That's a large part of the relevance, but it also goes to show quite how significant the occurrence of an event of default is, quite how complex it is, and why, therefore, it could not have been intended by implication, no more than that, in clause 9.1.1, that what was referred to there was an intention and meaning of the parties that all of this can be pushed to the Russian courts.
There's no particular reason to assume, is there, that a Vienna arbitration tribunal will have English law expertise? It might, or it might not. You might end up with, for example, a Russian lawyer appointed by the bank and an Austrian lawyer appointed as chair.
Yes, you might well do, Lord. But first of all, it also leaves open the possibility, the obvious possibility of English law representation being involved in that, and also the fact simply that the parties have identified VIAC arbitration as their preferred mechanism, so that they can include in that and choose within that tribunal the proper composition.
Well, you say their preferred method, but that's the whole question, isn't it? It's one of two methods that they've chosen. One is the Moscow court, the other is the Vienna tribunal. And one of the questions for us is the Vienna tribunal preferred?
Well, the issue that I'm addressing at the moment, Lord, is what we take this in stages. Obviously, what do the parties intend by the terms of the arbitration agreement, by the terms of clause 42 of the facilities agreement? And we say, when you look at the complexity of the facilities agreement as a whole, not just clause 23, but the complexity of the facilities agreement as a whole, their clear intention, including by reference to the exclusive terminology of the arbitration agreement, was that those complex agreement would be, disputes arising from that complex agreement would go to their chosen specialist dispute resolution tribunal, namely a VIAC arbitration. How that might be composed in due course is a matter for them. But it wouldn't be right to second guess and say, well, it may not be an English law dominated tribunal. It will be a tribunal that the parties have, when the dispute arises, considered to be the most qualified to deal with the issues in dispute that have arisen. And very obviously, that is likely to include English law expertise. Now, all of that will be absent if a dispute over the occurrence of an event of default went to a Moscow court. That's why we say, looking at it commercially and sensibly, these parties could not, at the time of the facilities agreement, have intended, facilities agreement and the mortgage agreement, of course, could not have intended that anything that is said in clause 9, particularly clause 9.1.1, should, by implication only, oust what would otherwise be the clear jurisdiction of this arbitration agreement, namely that disputes over an event of default should go to a VIAC tribunal.
The Vienna tribunal will have to decide whether an event of default occurred on the date that the parties were contending it had, not at the time of the hearing, but back at the date when it was relied on as having occurred. Is that right?
I'm just trying to make sure I understand your Lordship's question. The Vienna Tribunal will be asked to decide whether an event of default has occurred at the time that it is alleged by UniCredit to have occurred.
Yes.
Yes.
Yeah. So
And that's what's meant by the occurrence of an event of default, an occurrence at that earlier date.
Yes.
So if we come back to clause 9.1.1, which
Yes.
is where I think we got into it's the occurrence of the event of default which gives rise to the entitlement to levy execution.
Yes.
Why do you say that in that clause, or do you say in that clause, occurrence of the event of default means not the date of its occurrence, but the date which it is later, at which it is later determined to have occurred?
Simply because if there is, because the wording in 9.1.1 does not address what is to happen if there is a dispute over the occurrence of an event of default. And because it doesn't engage at all in that issue, then the next question we respectfully submit is to say, well, which clause does cover that point? And the only clause that can cover that point, the only clause that obviously does cover that point, is the arbitration agreement.
So let's suppose that UniCredit say FHM committed a default by non-payment on January the 1st. And you say, well, now that's got to go to arbitration in Vienna. And on September the 1st, the Vienna Tribunal says, yes, there was a default on January the 1st.
Yes.
So that means that for 9 months, UniCredit had a right to enforce, which they couldn't exercise. Is that right?
Yes, because that is the effect of both the arbitration agreement and clause 9.1.1, or I should say in relation to 9.1.1, the fact that it doesn't purport to refer a dispute about that to the Russian courts. It just doesn't.
Doesn't that contradict the very words of clause 9?
No.
That between, on my example, January and September, there was a right that had been an occurrence, an event of default, which according to clause 9 gives rise to the right to enforce, but you say no, it doesn't. You've got to wait another 9 months.
Well, I would say let's look at it in the alternative scenario. Let's suppose that AO alleged an occurrence and it was proven that that there was no occurrence of an event of default.
Where was it proven?
Well, for this purpose, it doesn't matter where it's proved. The point I'm making is, in those circumstances, if 9.1.1 allowed AO to commence Moscow proceedings on the basis of their allegation of an occurrence of an event of default, which didn't transpire, which didn't occur, then it would have, they would on the terms of clause 9.1.1 have been no right to commence enforcement proceedings. So it works both ways.
Because the court would have decided that in the Moscow proceeding, the hypothetical Moscow proceedings.
But it wouldn't have had jurisdiction to do so, because there would have been no jurisdiction to commence the Moscow proceedings in the first place, because there would have been no occurrence of an event of default. So it works both ways. Then where does that leave us? It leaves us simply asking, under which agreement does this issue of an occurrence of an event of default fall under? Clearly, and there's no dispute about it, it is covered by the arbitration agreement. Then the question becomes, is it also covered by the by clause 9.1, clause 9? And for that, the question is, are there clear terms applying the BMP principles? Is there clear language to that effect? And there simply isn't. And the other point I'd make about clear language is that clause 9 itself, particularly clause 9.1, refers to an event of default in more than one place. It refers to it in 9.1.1 and it refers to it in 9.1.5a. The draftsman considered as was necessary the issue of the event of default in the context of enforcement proceedings. And with that in mind, and yet with that in mind, did not take the next obvious step of saying any dispute about that should fall within the terms of clause 21 of the mortgage agreement. And we say that is telling. It will be a glaring mistake if the parties intended an event of default to be covered by clause 21, then refer to it in the way that it did, that it did in clause 9, refer to it as the trigger for enforcement, refer to it also, within 9.1, also to the enforcement proceedings being subject to clause 21, but yet not take the trouble to say a dispute about an event of default also comes within this rubric.
Well, does that perhaps depend on what clause 9.1.5 means?
No. With respect, my Lord, I was going to come to that in good order, but I'll take that, because if we are right that 9.1.1 is just a gateway, that the gateway requires demonstrating an occurrence of an event of default, that goes to VIAC arbitration. We don't get to anything after 9.1.1 because the way that clause 9 is structured, and we can see this, 9.1.1 establishes the gateway. The subsequent clauses of 9.1 then discuss and only discuss the process, the procedure, the principles that apply once the gateway is triggered. That therefore includes 9.1.5, thus to be read that following the trigger of the gateway, once the right to levy execution has been triggered, the mortgagee shall not be obliged before exercising its right to levy execution, therefore assuming that the right has been triggered, subclause A, to take any action or obtain a decision, including from any court, arbitration court, or state authority. It's not deciding anything before the right has been triggered. It is deciding the position after the right has been triggered.
Which do you say is the clause that defines when the right is triggered?
9.1.1.
That is the occurrence.
The occurrence.
The occurrence of the event of default.
Yes.
And I think you say that doesn't mean when the event of default occurred. It means when it was subsequently determined by the appropriate tribunal to have occurred earlier.
In the event there's a dispute about it, and that must be right because an event of a default is not a factual position. It's not a factual situation. It's a legal situation.
That may be so. That doesn't mean to say it doesn't happen at a particular point of time. Many questions that affect termination of contracts, whether they're contractual rights of termination or repudiation, involve areas where there are disputes of fact and law, which may be in bona fide disputed and only resolved sometimes many years later, but they are resolved by reference to when the right was relied on, and there either was or wasn't a repudiation at the date relied on, there either was or wasn't an event of default.
Yes.
And the fact that it may be the subject of debate, which is going to be subsequently determined, doesn't affect the question of when it occurred, does it?
My Lord, but if there is a dispute about the occurrence of an event of default, and if it is shown that there was no event of default, then there is no right to levy execution.
Conversely, go back to my Lord's example, if 9 months later it is determined that there was 9 months earlier an event of default. The event of default occurred 9 months earlier, not when that decision is made, doesn't it?
But looking at it from the perspective of common sensible businesses, how would they approach this? What did they intend by it? And given the complexity of the events of default, given the fact that they are inherently and ultimately legal issues, the parties could not have intended by the reference to these words to have meant that all it took was for AO to assert that there was a right of default.
I understand all that. I think all I'm putting to you is that you do read 9.1.1, which you say is the clause that decides when the right to execute is triggered, as meaning when it is determined that there has been an occurrence of an event of default, not on the occurrence of the event of default. Is that unfair to characterise your argument that way?
Yes, it's not quite right. What we say is, it talks about the occurrence of an event of default. It doesn't engage in how a dispute as to whether an event of default has occurred is determined. Therefore, that issue needs to be addressed by looking at the ordinary terms of the arbitration agreement and alongside other relevant agreements, but applying BNP. And that's where you get to the conclusion that the occurrence of an event of default, if disputed, must first be determined. So we don't say that it has to be reread.
Sorry, you carry on, then I've got a question I'd like to ask you.
Yes. We say that when you reach the conclusion, as respectfully submit you must, that 9.1.1 simply doesn't engage in the dispute resolution procedure for an occurrence of an event of default. That's a separate question.
Can I go back to my hypothetical example?
Yes, of course.
UniCredit asserts an event of default on January the 1st, and the Vienna Tribunal decides in September that yes, indeed, UniCredit was right, and there was an event of default which took place on the 1st of January. Your argument, I think, is that UniCredit cannot levy execution until the Vienna Tribunal renders its decision.
Yes.
So that would mean that the event of default, which took place on January the 1st, did not give rise to the entitlement to levy execution, which is a default contrary to what 9.1.1 says. And even insofar as you say the right to levy execution is suspended, it also contradicts 9.1.2, which says that the mortgagee may levy execution immediately after the occurrence of the event of default, i.e. not having to wait until a subsequent tribunal decision confirms that that event of default did take place.
Mr. Simpson wants me to make the point that in that scenario, UniCredit has an inchoate right, which only crystallises upon the issue by the VIAC tribunal of an award confirming the occurrence of an event of default.
We're talking about a right to levy execution.
Yes.
An inchoate right that is in some way suspended isn't much use if the execution is on assets which are no longer there 9 months later.
But the proper starting point, we respectfully submit, is what do the parties intend by what is said in 9.1.1 alongside the arbitration agreement?
Your answer to that question has so far depended on what you say is the complexity of the various terms referring to an event of default in the facility agreement. What if those terms were not so very complex? What if they were quite straightforward? Would then the language of clause 9.1 mean something different? Does it vary according to the complexity or otherwise of the definition of event of default?
Possibly it may, but that's not surprising because it's consistent with the contractual principle that you apply the meaning of words to reflect the intentions of the parties by taking into account other relevant clauses. But the other point I would make in response is that an event of default is not a factual concept. It is a legal concept. And therefore, simple or not, if it is a legal issue that needs to be established, then it has to be established legally in the absence of an agreement.
Well, why doesn't 9.1.2 tell you how you do that? The mortgagee may levy execution immediately after the occurrence of the event of default in accordance with the terms and conditions of this agreement and subject to clause 21, brackets, dispute resolution.
Because the word...
So if there is a dispute, the natural meaning of clause 9.1.2 is that clause 21 will decide it. And 9.1.3 tells us that you've got to go to court.
Well, if we look at 9.1.2, what it says, and I think we can ignore the first two lines. The relevant lines are these: the mortgagee may levy execution on the mortgage property immediately after the occurrence of the event of default, in accordance with the terms and condition of this agreement, subject to clause 21. Now, the reference to in accordance with the terms and conditions of this agreement and subject to clause 21 is, I respectfully submit, a reference to the levying of execution. It is simply saying that it is the levying of execution that must be undertaken subject to the terms of the agreement, subject to clause 21. It is not saying that the occurrence of an event of default must be adjudicated subject to the terms of the agreement in clause 21.
What are the restrictions that they've agreed shouldn't apply? Do you happen to know?
Oh, I'm sorry. You're talking.
Yeah,
Lord is
part 3
talking
of
about
Article
part
348 and
348.
so they're obviously the parties, whatever they are doing, are trying to remove restrictions to
Yes.
levying execution, whatever those restrictions are.
I think, and I'll stand to be corrected, but I'm trying to recall because I think this issue arose below, so I'm trying to recall from that. I think it is the obligation under Russian procedural law to serve a letter of action.
Right.
I think that's right. I will check. I'll make sure.
Pre-action protocol type thing.
Yes. But Lord, I think we've debated 9.1.1 and
From which we
9.1.2.
might deduce that the parties wanted speedy execution if they have cut out some of the procedure required under Russian law.
Well, we would say what 9.1.2 says, yes, speedy execution after the right to levy execution has been triggered, yes, but not before.
Is a dispute whether AO is entitled to levy execution under the mortgage agreement immediately on the occurrence of an event of default without first getting a decision from the Vienna Tribunal. Is that a dispute arising out of or in connection with the mortgage agreement? And if not, why not?
Applying English principles. Yes, it would seem to be because the mortgage agreement is couched in the same broad terms as the arbitration agreement, but this is precisely the scenario that BNP was addressing, that you can have inadvertently in a situation of a complex series of transactions overlapping jurisdiction clauses which, if read in isolation, would plainly encompass a particular dispute, even though that dispute most naturally arises under another competing jurisdiction clause. And what BNP says very, very clearly is in those circumstances, unless you can apply an exception, the presumption, the starting presumption, principle 5, is that the clause under which the dispute most naturally arises takes precedence over the competing clause. So the fact that in isolation, clause 21 of the mortgage agreement would tend ordinarily to capture a dispute over the occurrence of an event of default because that is in connection with, doesn't arise out of, but it is in connection with, is missing the relevant point, missing the BMP point, is what we respectfully submit.
But if the dispute arises because AO is trying to enforce the mortgage, isn't it more naturally situated within the mortgage agreement, to use your expression?
My lord, no, because the event of default is a breach that arises only under the facilities agreement. It is an issue that is addressed in extensive detail only in the facilities agreement. And just to make good that point, can I ask your lordship to look very quickly at the full version of the mortgage agreement, which is in your supplementary bundle.
Yeah.
And the relevant pages have fallen out of my bundle, so I need to put them back in.
Starts at page 5.
So we're looking at the mortgage agreement. It starts at page 135. Can I turn your lordship's attention, please, first to page 137, which is the definition section, the beginning of the definition section. And you'll see there 1.1 definitions. In this agreement, all terms and definitions shall, unless expressly stated otherwise, have the meanings attributed to such terms and expressions in the facility agreement. And such terms and definitions are incorporated into this agreement by setting them out in Schedule 2. We then go to Schedule 2, which your lordships will find at page 168. You'll see there that it's entitled Terms and Definitions of the Facility Agreement, not the mortgage agreement, the facility agreement. And 1, 2, 3, 4, fifth definition, event of default means any event or circumstance specified as such in clause 23, namely clause 23 of the facility agreement. Now, ready for your lordships to get to that. So we say that those clauses themselves plainly recognise that issues relating to an event of default primarily and naturally arise under the facility agreement and not under the mortgage agreement. Well, Lord, I'm just seeing where we've got to because we've been
Yes.
talking about various aspects of clause 9.1, and I just want to see which points we've already covered from my notes. I think we've said everything we need to say about 9.1.1 and 9.1.2. His lordship also relied on 9.1.3. Now that simply says the mortgagee may levy execution under the agreement only in a judicial procedure. But our simple point about that is a similar one. This says nothing about how a dispute about the occurrence of an event of default is to be resolved. It only talks about what is to occur once the right to levy execution has been triggered, i.e. only in a judicial procedure, quote unquote.
Yeah, you always come back to the same point.
Yes. But I'm sorry, I'm just going through the.
No, I
it-
follow,
it-
but,
it is-
but the judge thought it was a safeguard
Yes, it was
for,
yes,
for
exactly,
the
exactly,
mortgagor.
exactly.
And then you say, well, that doesn't answer the full
Exactly,
point,
the prior
which
one.
is that all this only takes place after the arbitral tribunal has decided that there has been an event of default.
Quite, my lord.
Sorry to keep bombarding you with questions. Does Russian procedure afford interim measures of preservation of assets by way of execution?
Not to give evidence, but yes,
So
I'm pretty certain it does.
go back to my lord's example of January the 1st alleged event of default. Vienna tribunal 9 months later. Is it your case that those interim measures would not be available because there wouldn't have arisen a right to levy execution at that stage?
So the interim measures under Russian law, available to a Russian court under Russian law, whether they would be available
Yes.
to the parties.
January the 2nd,
Yes.
UniCredit say, we need to freeze this asset because they're about to sell it. No right to invoke those interim measures because no existing right to levy execution. Is that your case?
That, my lord, and I'm just analysing it off the top of my head, but that would be a procedural issue, not a substantive law issue. It would therefore be a procedural issue governed by Russian procedural law. It may well be, I really don't know the answer to this, that Russian procedural law is flexible enough to allow interim measures to be granted prior to the issue of proceedings is available to the English courts.
Prior to a right having arisen at all to levy execution.
That will be a matter of Russian procedural law, whether it's flexible enough to apply in those circumstances. But it has nothing to do, I respectfully submit, with how one interprets the arbitration agreement.
Because this doesn't it? That doesn't sound like a very sensible commercial result that the parties would have intended.
Well,
if they are considering the remedies that should be available to a lender, if it should transpire that they are entitled to execute.
Not necessarily at all, because there's nothing to stop the lender seeking relevant interim relief, either from the English courts or from a VIAC tribunal or from the Austrian courts as the seat of the arbitration.
If one transposes it to an English context, if the argument was you haven't yet got a right to execute, the English court would probably say, well, then we haven't got power to order interim measures in relation to some potential future right that's not yet arisen.
That would be very surprising, because imagine a situation of a freezing injunction. A freezing injunction is granted on the basis that the parties are able, so the claimant is able to demonstrate a good arguable case of a right in support.
An existing right, not a good arguable case that a right will come into existence sometime in the future. That's what all those cases were about.
And where it is
About having to have your cause of action before you were entitled to relief.
Well,
Of course,
there are
subject to having to prove it and whether it's sufficiently arguable and so on.
Yes.
But the cause of action has to have arisen in English. Anyway, you say it's a matter of Russian procedure.
Yes, but the cause of action is based on an allegation of a breach of a right, of course. But
Existing right. But
Well-
you say, as a matter of construction in this case, there is no existing right at the moment of the event of default. There is no existing right to levy execution until it's been determined that there has been an event.
well, UniCredit has got a range of rights. It's got a range of rights under the facility agreement. It's got a range of rights under the mortgage agreement. Some of those rights are conditional. The question in this situation, I think the scenario your Lordship is pointing to, is there is a dispute as to whether a specific right has materialized in the sense of has the precondition for exercising it been come into existence. But there's no reason that I can see, my lord, why a court could not protect, by way of interim measures, that conditional right pending the determination as to whether or not it's come into existence. It doesn't depend on the right to levy execution already existing, it is sufficient that the right to levy execution is alleged to already have been triggered. There is sufficient flexibility to the tribunal and to, well, I don't want to give evidence but Austrian law, but you would imagine, to deal with that. There's nothing uncommercial about that situation. The other point that Mr. Justice Henshaw made in relation to 9.1.3, which I'll deal with very briefly, is that the reference to judicial procedure would not, if it's interpreted as applying to a dispute which would otherwise fall within the arbitration agreement, would not result in depriving Fashion House of any valuable right. Your Lordships will remember, I'm sure, of what we said in our skeleton argument about
Yes.
that. It's taking away the right to go to a VIAC tribunal, which is a valuable right. Self-evidently, it's a valuable right. So we say
Both the parties, by agreeing in the mortgage agreement that they will go to the Moscow court, likewise regard going to the Moscow court as a valuable right. So that's a circular argument, isn't it?
Well, let me put it this way. It begs the question. If we are right, if we are correct that the arbitration agreement grants exclusive, I suppose this is the context in which I think His Lordship was looking at it. There's an arbitration agreement under which a dispute over an event of default would ordinarily fall and be subject to VIAC tribunal. The issue in his mind, I think, was whether the effect of finding that it also fell within the scope of clause 21 of the mortgage agreement would have the effect of depriving Fashion House of going to the VIAC tribunal. And I think he was looking at it more in a commercial as well as a legal sense. And we say, yes, if the effect of this would mean that issues about foreign law illegality, issues about estoppel were dealt with by a Russian judge rather than a selected VIAC tribunal, the commercial effect of it would be to take away a valuable right.
It's a valuable right for UniCredit, but they don't have to wait for a Vienna arbitral tribunal. The contract tells them, if this is what it means, that they can go straight to the Moscow court. So I'm not sure that saying one right is more valuable than the other takes you very far.
I accept that it's very much a secondary question. It really does depend on or the question here turns on the interpretation not of 9.1.3 but 9.1.1 in particular, 9.1.2.
Do you say that one reads this kind of clause as a whole? I mean, your argument really chops it up into saying, well, 9.1.1, that's the gateway. And if you don't get past the gateway, then nothing else in 9.1 really matters. So that when the judge says, well, you've got to go by judicial procedure, you say, well, that doesn't affect the gateway.
Yes.
Is that the right approach to interpreting a clause of this kind?
That's not forgive me if that's how it's come across, but we're not saying that each of these subclauses should be interpreted in isolation. They very much should be interpreted in context, not just of 9.1 as a whole, but the mortgage agreement as a whole and the linked agreements to which they are a part. Yeah, absolutely, yes. Lord, that's 9.1.3. The 9.1.5, we've discussed this in to some extent. It's probably the most it's the issue that gave rise to the most discussion both below and in the judgment, albeit only in 2 paragraphs in the judgment. But you will see that His Lordship relied on the phrase arbitration court in 9.1.5a as meaning arbitration tribunal and as covering therefore the VIAC tribunal, and came to the conclusion that it supported his interpretation of 9.1.1 and through to 9.1.3. And specifically, he said that any other interpretation would render the purpose of 9.1.5a unclear. And his reason for that is because it's common ground that no permission for execution was needed from another Russian court. But as to that, firstly, and forgive me for repeating myself, it only deals with the procedure after the right to execute, to levy execution has come into force. Secondly, as to the purpose point, reliance was placed on the evidence of UniCredit's Russian lawyer in Moscow proceedings, Ms. Trasova, who gave evidence that she wasn't aware of any relevant permission that might be needed from another Russian court to levy execution. But that applies as much to the phrase court and the phrase state authority as it applies to the phrase arbitration court. So in circumstances where there was no identifiable reason or practical reason for referring to court and referring to state authority, there was no justification, we respectfully submit, to then striving to find a purpose for the phrase arbitration court, and for that reason deeming it to mean arbitration tribunal. So we say all that 9.1.5 does is to provide a belt and braces clarification that no further steps are required before enforcement, for the purpose of enforcement, once the 9.1.1 gateway has been triggered, without addressing how that latter issue is to be determined. So it's surplusage. And surplusage is not uncommon in detailed, complex agreements such as this. So there was no proper basis for the judge, we respectfully submit, to conclude, to interpret arbitration court in the way that he did. But alongside that, it was the respondents who were relying on this particular subclause and the meaning of arbitration court as signifying arbitration tribunal. And therefore, we submit the burden was on them to put their case clearly below that this was the proper meaning of that particular phrase. And we say...
Well, on your interpretation, which is that you have to get a decision of the Vienna Arbitral Tribunal before you can levy execution, presumably there would be formal steps that you then need to take in Russia with the award. Would you need, for example, to register it or to seek to have it recognised or enforced by the Russian court? The very least you would need to do would be to put it in evidence, wouldn't it? Because if it's not in evidence, the Russian court before which you're seeking to levy execution won't know about it, so we'll throw you out. So on your case, whatever precisely you need to do, there would be some formalities necessary after you have got your award from Vienna.
I don't know the minutiae of Russian procedure law after the issuance of a hypothetical Vienna arbitration. It doesn't follow from our argument that additional formal steps in Russia are required. Our case is simply that once an occurrence of an event of default has been proved through the recognized mechanism of an arbitration, of VIAC arbitral tribunal, then 9.1.1 is triggered and the other subclause is applied.
Even if Russia is party to the New York Convention, suppose there were New York Convention grounds which existed or were alleged to exist, which would prevent enforcement of the award in Russia. If those arguments were raised, whether or not there was an application to enforce the award, would that have any bearing on it, or would you then have a right to to enforce? Would UniCredit have a right to enforce even though there was a challenge to the award?
Again, it's an issue that I'm analysing off the top of my head. It seems to turn in large part, at least, on Russian procedural law. It may well also turn on international interpretation of New York Convention provisions. But on the terms of 9.1.1 itself, no. There's no need to take any further step. The gateway has been triggered. Then, following that, we look at 9.1.2, etc., etc. If there are aspects of Russian public policy, for example, which collide, well, that's a matter for Russian law.
They collide, and
I don't know. I've no idea.
Suppose that Austrian procedural laws, the law of the seat, allows a form of appeal process. Never mind how narrow or how wide it is. Does the right to execute, to levy execution, arise before that appeal process is gone through? As a matter of construction on your case?
Again, let me just analyse that. It may well be that if there is it's an arguable point as to whether the occurrence of an event of default will be deemed to have been proven at the award stage in circumstances where there is then an appeal against the award or thereafter. But that's a secondary issue because on our interpretation, it's got to go to Vienna anyway.
Well, the argument against you as a matter of construction is very straightforward. Occurrence means occurrence. Your argument involves it meaning determination that there has been an occurrence. And I'm just pressing you on when you say that determination occurs.
On the issue, well, on the issue of an award, but your lordship has raised a complex point which I don't have the answer to off the top of my head because it involves understanding what the procedure is in Austria once an award is issued. And I can't answer that question without that context.
Isn't that a necessary question in order to support your interpretation? To be able to say to my lord, well, the event has been determined on the issue of the award by the tribunal, or, well, it's provisionally determined subject to appeal?
Well, I think we just need to have a quick look again at the arbitration agreement because from recollection, I think it refers to finally resolved. Yes, it does. So, clause 42.1, which you'll find at page 178 of your core bundle, says any dispute arising out of or in connection with this agreement shall be referred to and finally resolved by arbitration under the rules. So there is certainly finality there. One would then have to look at the rules to understand when that finality arises.
Yes, that was my lord's question.
Yes, but if it should not make any difference whether or not there is an appeal process. If the parties have agreed that this is the trigger, then you have to go through this process.
Yeah.
So on your approach, if the Russian judge is doing his job properly, that's to say interpreting these agreements correctly, when UniCredit turn up and say there's been an event of default and we want to levy execution now, the Russian judge should say, well, before you can do that, you must show me an award of the Vienna tribunal, which I, the Russian judge, am required to recognise.
Yes, the Russian judge should say, dealing with this properly, is that I don't have jurisdiction until an occurrence of an event of default is proven, and where is the proof? And I don't have jurisdiction to determine that.
So there does need to be some process for recognition of the award in Russia before the right to levy execution accrues, on your approach.
Well, I think it's a difference between recognition and evidence. What clause 9.1, clause 9 says, or the effect of clause 9 is, we say, once you get an award from the VIAC tribunal that proves an event of default, you have proven the occurrence within the meaning of 9.1.1. You show that award, you've proven the occurrence for the contractual purpose of 9.1.1. The gateway is triggered, which is different from the enforcement of an arbitral award in a normal sense. One is just talking here about how one interprets 9.1.1. Well, Mr. Simpson wants me to draw your attention to the fact, I think you have it, that the terms of the arbitration agreement are, of course, mandatory.
So it says clause 21 of the mortgage agreement.
My lord,
So is clause 21
Yes,
of the
yes.
mortgage agreement.
Absolutely.
They're both mandatory.
they are both mandatory. This is so the legal issue is how one resolves that clash.
Yes, but
It's
just
clear.
but to
It's
say that the arbitration agreement is mandatory doesn't get you very far, because so is the dispute resolution clause in the mortgage.
Well, it's the starting point. It's the starting point of this process, that because it's mandatory, and yes, there is another clause which is also mandatory under which this issue would ordinarily arise. How do you deal with that conflict? You then get to BMP, and you see what we say about BMP.
Well, why is it the starting point? The whole premise for whether there should be an anti-suit injunction is whether UniCredit are doing something which the agreements don't allow them to do.
Yes.
One might have thought that the starting point is to decide what the scope of clause 21 is, because that's the jurisdiction clause that's being invoked.
Yes, but the jurisdiction clause, I would submit, it doesn't matter whether you start with clause 21 or whether you start with the arbitration agreement. The fact is they're both part of one suite of agreements. You then have to look at those two jurisdiction clauses together. You then identify the fact that they are overlapping in their scope. From that point, you ask yourself whether you start with 21 or whether you start with 42.1, which is the clause that into which a dispute over the occurrence of an event of default most naturally fits. So the starting point is not pertinent.
So your submission is that they are overlapping, even on your case. They're not mutually exclusive.
Lord, we say, if you interpret them individually on their plain and natural wording, yes, we accept that an event of default could fall within both. It could fall within 21. But that then leads to an entirely uncommercial result. And that is precisely why we say you have to choose between the two. That's what BMP mandates, choosing between the two. And the choice between the two is clear in favour of the arbitration agreement.
I had thought it was your case that they are ultimately mutually exclusive.
Ultimately, yes, absolutely. I mean, sorry, yes, I see what you mean. They overlap if you read them. Yes, absolutely right. They overlap if you read them literally. They are exclusive if you apply the BMP principles.
Well, I think your answer to my lord there depended largely on what you say would be an uncommercial result. So is the question then whether it is more uncommercial to have to go to Vienna before you can go to the Moscow court, or whether you are allowed to go straight to the Moscow court? Because Vienna seems like quite a long diversion.
I think that is certainly a significant factor. What must the parties have intended? Ultimately, this is what BMP focuses on.
I thought this was the decisive factor. Well,
Yes,
I may have misrecorded your submission, but what I thought you said was that if you interpret the two clauses individually, they are overlapping. That is an uncommercial result, and therefore applying the BNP principles, you
Yes.
must choose between them,
Yes,
so that in effect one overrides the other.
yes, that is our case. Yes.
So it's not just the uncommerciality is significant; it's the linchpin of the whole argument.
No, well, to be clear, what BNP says at the end, Principle 5 and Principle 6, is notwithstanding the uncommerciality. In certain circumstances, you may have to reach the conclusion that they are overlapping. So,
Yeah.
the question then becomes, because that is counterintuitive, is there clear enough language in clause 21, or clause 9 and clause 21 of the mortgage agreement, to displace what is not disputed, which is an occurrence about an event of default plainly does fall within the arbitration agreement? That's the question.
Is it relevant when considering where the commercial good sense lies to take into account that enforcing security is something in which time may be of the essence and very important?
You have to, I would say you need to take that into account alongside the alternative of overlapping clauses existing with the illogical commercial consequences that would follow. Ultimately, it is what would these parties objectively have decided at the time they entered into the suite of agreements in relation to this issue, having regard to the wording that they used. And there are competing arguments, but we say that the chaos that would follow from overlapping jurisdiction clauses by far outweighs the efficiency, if you like, of dealing with everything very quickly through the Moscow courts, particularly given the size of this facility agreement. That too needs to be borne in mind.
Well, it cuts both ways, doesn't it? If being able to realise your security in sufficient time for it to be useful, one might be said, the greater the sum at stake, the more weighty that consideration is.
We would say that the position of the borrower is more important than the position of the lender, but then we would say that. With an eye on the clock, unless I can assist you further on this particular point. Yeah, I'm going to come back. But I think this is, just looking at my notes here, this is a convenient point for me perhaps to go through why we say this is so commercially lacking in logic. We do set this out in our witness statement, but it is a critical, skeleton argument, it is a critical issue. So I will go through the points we rely on in this regard.
This is paragraph 47
Of our skeleton?
of your skeleton.
Yes, I think it, from recollection, 47. Right. Yes, so the first point is that the exercise we're about to go to is of course part of the unitary interpretive exercise which my Lord Justice Popplewell was I think the first to identify as a critical principle and then emphasised in Bund Capita. So let's step back and look at the implications. It would mean that the same dispute will be referred to both the VIAC Tribunal and the Commercial Court of Moscow. There's no suggestion at the moment that we still couldn't do that.
You haven't done it, have you?
We haven't done it, no. That would lead to the obvious risk of chaos from conflicting judgments, an unedifying race to judgment, and unmeritorious, I would say also, race to judgment, with all the duplicative costs and delay that would entail. Secondly, we say that the reality is that disputes over an occurrence of an event of default with immediate enforcement consequences are by far the most likely type of dispute, the most important type of dispute that the parties would have had in mind when they entered into the facilities agreement. They obviously arise out of the facilities agreement. So to interpret the two competing jurisdiction clauses as permitting the Moscow court to take the lead on this because it's quicker at it, because it will be quicker than a VIAC tribunal, would have the result of depriving the arbitration agreement of its primary function, of its most identifiable function at the date that this agreement was entered into, that the arbitration agreement in particular was entered into. That can't be what the parties intended. Does not make sense. I've made the point, this is our third irrationality. There is no clear language which demonstrates that the parties had intended it as required under BNP. I've noted to your lordship that clause 9 addresses directly the importance of an event of default, but only as a trigger and not by way of making it clear that disputes about that fall outside, are ousted from the arbitration agreement and fall only within the clause 21. Our fourth point, so there's no clarity at all that's required to reach the conclusion that these are overlapping clauses. Our fourth point is that what you then have is in reality the mechanism, the dispute resolution mechanism under clause 21 taking precedence over the arbitration agreement in terms of likely disputes. And we say that would be to ignore the fact that the facilities agreement is the primary agreement. It's the primary agreement within the suite of agreements. It is the hub of the parties' financial scheme, in relation to which the mortgage agreement is nothing but a mere spoke, as well as the other security agreements, the various others. This is the primary agreement. So to interpret clause 21 as taking over in reality and in practical terms the arbitration agreement is to ignore the primacy of the facilities agreement when compared to the mortgage agreement. It is to let the tail wag the dog. And then finally, it results in this, that the Moscow court would end up determining, or actually in this case, refusing to determine important English law issues, including alien concepts of foreign law illegality, estoppel, but also, I draw your lordship's attention, misrepresentation under clause 23.4, hypothetically, unlawfulness and invalidity under clause 23.1, hypothetically, repudiation and rescission under clause 23.2, and a host of insolvency concepts under clause 23.7. And indeed, it is not irrelevant that in this particular case, this Russian court simply refused to apply English law. I don't know if your lordships picked that up from the judgment. Just ignored it. Now, objectively, that must have been one of the issues that, as sophisticated businesses, these parties, particularly Fashion House, had in mind when they entered into the arbitration agreement, drafted it in the wide terms that they did, and required issues arising out of or in relation to the facilities agreement to be referred to a VIAC tribunal. Stepping back as business, they could not have intended that it should slip out of the arbitration agreement via clause 9.1 and end up this English law issue. All these English law issues end up before a Russian judge who was very likely to ignore it, as has happened in this case.
Well, why do we assume that the parties at the time of this agreement would understand that the Russian judge would be likely to ignore English law? The fact that some years later the Russian court did ignore English law doesn't tell you anything about that.
I suppose, to be fair, that probably requires expert evidence as to the fact that this is not an unusual occurrence.
Of which there is none.
That's what I'm saying. But you don't need expert evidence to imagine that objectively the parties would have been concerned, at least as to how effectively all of the concepts in clause 23, as well as other terms of the facilities agreement, would be applied, interpreted by a Russian court. Common law concepts by a civil law judge. And these are extremely important practical commercial points, iterative points for your lordships to take into account in deciding, did they really intend overlapping jurisdiction clauses?
But on the other hand, they chose an arbitration agreement governed by Austrian law, to which Austrian procedural rules will apply. And we have no idea
Yes.
how an Austrian tribunal would go about deciding questions of foreign law.
But it is entirely foreseeable that they would have entered into that agreement objectively on the basis that they would pick the right tribunal for the dispute once it arose, and quite foreseeably and predictably that would have included some element of English law representation, but certainly better qualified than an abstract Russian judge over whom they had no selection rights. Yes.
In terms of intention, it was English law originally.
Mr. Simpson wants me to make the point that at the time they entered into the agreement, facilities agreement, Anchor and Chubb applied, in which case English law would have applied to the arbitration agreement as well. Lord, unless I can help you, those were our submissions on ground one.
Right?
I come now to ground two, which is about the scope of the court's jurisdiction under CPR.
Had Anchor and Chubb been decided by then?
Good question. Mr. Simpson will have to check the dates.
I suspect the answer is no.
It's not the decision maker in Chubb, it's the principle applied, and it was reversed by the Arbitration Act 2025.
The point Mr. Simpson wants you to make is that it's the principle in Anchor and Chubb that existed at the time.
Principle was interpreted differently by the Court of Appeal in that
Yes,
case
exactly.
from the Supreme Court.
Exactly. I come to ground two. So this is about Practice Direction 6B and the scope of paragraph 3.16C, which is your lordship will, you've got a copy of it, by the way, in your authorities pamphlet, page 637. It permits, as your lordship will have picked up, service out with the permission of the court for a claim in respect of a contract governed by English law. Therefore, what do we mean by in respect of a contract? That's the issue. And as far as we are aware, my lord, this point in the context of an arbitration agreement governed by foreign law, but forming part of an English law contract, has not been considered before by the courts. We're not aware of a decision that has. The point was raised before the Supreme Court in UniCredit and Ruschem Alliance. But as you will see at paragraph 19, I'll give you just the reference for it for the moment, page 543 of your authorities bundle. The Supreme Court refused to consider that point in that case because the argument had not been raised below. So we think this is the first time that the courts have been asked apart from Mr. Justice Henshaw, of course, to consider the scope of this. Starting point is Alban Motors and Nazar Motors. Would your Lordship find it helpful if I took you to the authorities, or are the arguments in our skeleton about this?
Well, we've read what's in your skeleton. If you want to develop those arguments or show us particular passages in the authorities, please do.
Thank you very much. In which case, I think, yes, I would ask your Lordships to quickly look through the authorities I'm going to take you through. I'll take you simply to the relevant passages. If your Lordship wishes to look at other surrounding passages, then please do, of course, tell me. Alban Motors is a starting point. Tab 3, there are two decisions in Alban Motors. We start with tab 3, which is the first of the two decisions. This related to an alleged oral contract that was said to be governed by English law, and there was a claim for restitution that was brought in relation to overpayments that it was said to have been made in respect of this oral contract. And the question was, therefore, whether the restitution claim was a claim made in respect of an English law contract. That was the context. Now, Mr. Justice Lightman addressed the gateway issue at paragraph 25, which your Lordship will find at page 452 of your authorities bundle.
Sorry, which page?
52. At the very bottom, you'll see the heading gateway.
Yeah.
So we start at the very bottom. First question is whether it's a good arguable case that Mr. Alban's claim in respect of the UK agreement fell within, and this is the predecessor, but in identical terms to what we're considering, so Rule 60.25. And for this purpose, it's necessary first to consider the as yet unresolved issue whether for the purpose of CPR 6.25, a claim in respect of a contract must be a contractual claim. This was a restitution claim and effectively reached the conclusion, analysed the restitution point in the context of Westdeutscher, amongst other things. But then...
That's the conclusion he reaches at paragraph 27.
Yes, yes, he talked about Westdeutscher and then reaches conclusion 27. But 26, he says this, but in my judgment, claims under the Gateway 625 are not confined to claims arising under a contract. It extends to claims made in respect of a contract, and the formula in respect of is wider than under a contract, referring to Tatum and Reed, and points out that the provision, that new provision, was deliberately wider than its predecessor in the Supreme Court rules. Then in 27 says the formula does not require, in respect of a contract, does not require the claim to arise under the contract. It requires only that the contract relates to or is connected with, claim relates to or is connected with the contract, making the point that that is the clear and unambiguous meaning of the words used in respect. And then by reference to Australian Appellate Authority, trustees, executors, at B, he quotes the finding of Mann CJ there. The words in respect are difficult of definition. They have the widest possible meaning of any expression intended to convey some connection or relation between the two subject matters to which the words refer. And then he makes the point, I'll draw your attention to at the end of 28, claims in contract and restitution and repayment are overlapping alternatives for jurisdiction purposes, I should say. The necessary relationship and connection between the claim and the UK agreement is established. It's worth pointing out that in this case, there was an alternative gateway, the restitution gateway, but the claimant chose not to pursue that gateway because it didn't fall under it. And so the reason for under this alternative with the English law connection, English contract law connection. That's Alban Motors. I'll come to the second decision in Alban Motors in a moment, but can I just ask next to your lordships to have a look at what Lord Justice Tomlinson said in Alliance and Aquanta. So that's tab 11, starts at page 231. And I'm just going to refer your lordship to the comment at paragraph 63. Lordship's analysis in 63. Page 222. Oh, I'm sorry, now I'm looking at the wrong pagination, page 270. You see there, top of the page, paragraph 63, Lord Justice Tomlinson refers to the previous gateway under Order 11 and makes the point that that was, under that gateway, it applied to a claim brought to enforce, rescind, dissolve, annul, or otherwise affect a contract or to recover damages. And then going down a little bit to C, there's this. In the present formulation under the CPR, the formula of under a contract is likewise avoided, but the language of the gateway is simple as well as broad. A claim is made in respect of a contract which has the necessary connection with England, such as being governed by English law. The new formulation is undoubtedly more broad than its predecessor. It's worth at this stage, just for efficiency, also noting what is said at D and E. By reference to the Court of Appeal decision in Greenwood, his lordship also said the remoteness of the connection with the contract upon which reliance is placed is something which can be dealt with when the court considers whether England is the proper place, forum convenience, proper forum, if you like, to be brought. So it's not an issue which is relevant to the existence of the gateway. It's just an issue that's relevant to the exercise of discretion. Even so, he said, I'm intuitively resistant to the notion that Gateway 6 can be used to justify service out of the jurisdiction by reference to a contract to which the intended defendant is not a party. And that was the critical issue in Alliance. But it is not it's not relevant, doesn't arise in our case, because the related contract we rely on is the facilities agreement, to which, of course, AO and SPA are parties. So that's Alliance Bank, again making the point about the broad language. Then if we go, please, to the second decision in Alban, which is at tab 4. And paragraph 20, please, at page 65. You'll see there that Mr. Justice Lightman says at 20, in my first judgment, I had to consider the ambit of 60.25, provides that a claim form may be served out of the jurisdiction of permission in respect of a contract, where the contract is governed by English law. I held that this required only that the claimant relates to or is connected with such a contract. The issue now before me is whether to grant an anti-suit injunction in connection with a contract governed by English law. So much closer to the situation, not directly on point, but much closer to the situation we are dealing with. Governed by English law is a claim made in respect of the latter contract. And then by reference to Yoel, your lordships do have a copy of Yoel at tab 2. I'm not going to take your lordship to that at the moment. That where Yoel held that such a claim was a claim which affects a contract, therefore within the meaning of the previous RSC rules. If the claim is one which affects such a contract, there can be no doubt that it is a claim which is made in respect of such a contract. And then whilst we're here, and again for efficiency, I draw your lordship's attention, because this is an issue which will become relevant in the last point I'm going to deal with in my opening submissions. Last sentence, CPR 62 has no application to claims such as the present in respect of foreign arbitrations. It's dealing with a point raised in the respondent's notice. Nevertheless, of course, held that anti-suit claim did fall within this jurisdiction. Perhaps just to finalise paragraph 21, about 5 lines down, the general rule is that the court does not have jurisdiction to grant anti-suit injunctions against a defendant who is a foreign party brought into the jurisdiction by answering a claim in 620. The position, however, is different if the foreign party is willingly submitted to jurisdiction without reservation or has invoked the jurisdiction, but that is an issue which is superseded by the Supreme Court's analysis in UniCredit. So that is the second Alban decision. Then if we go to, I think it's worth briefly going to Greenwood, please, which your lordships will find at tab 5. This was a contribution claim. This is a contribution claim made by a firm of solicitors in relation to an ATE contract that the solicitors had obtained on behalf of their clients, but to which the solicitors were not a party. And the insurers refused to pay out, in effect, under the ATE contract governed by English law. The solicitors brought, therefore, contribution claims under the Civil Liabilities and Contribution Act 1978, Section 1.1. Question was whether or not the insurers, being an Isle of Man company, whether or not there was jurisdiction to serve out, because the contribution claim was in relation to the English law insurance contract. So first of all, perhaps if we can just quickly look at the head note, page 73. So it's the second page of the judgment. Number 2 in the middle of the page, brackets 2. Dismissing the defendant's appeal. A claim for contribution under the Civil Liability Contribution Act, which had a connection with a contract governed by English law, was a claim in respect of that contract within the meaning of 625, even if it were not a claim brought under the contract. Also making the point, the question of remoteness of the connection would be dealt with when the court considered whether England was the proper place. And the detailed analysis your lordships will find, which reflected that point, your lordships will find at paragraph 17 on page 79.
Yeah.
And in paragraph 17, we pick it up just below D. Can it be said that GWM's claim, so those are the solicitors, is in respect of a contract? It's not a contract to which GWM was a party to, which is the paradigm case of a contract pursuant to which permission is given under Rule 6025C. And that is, the paradigm case being it's a contract between the intended claimant and the intended defendant. But then to pick that up at 18, beginning of 18, to say for a claim to be in respect of a contract, it must be in respect of a contract between the intended claimant and the intended defendant, is to add words to the rules which are not there. Now I say that, although those particular facts don't apply to this case, what that shows is his lordship just applying the natural meaning of the words without imposing and introducing words to restrict the ambit of that jurisdiction, which we respectfully submit is the proper course. And then in 19, the claim in the present case clearly has a connection with a contract governed by English law. To my mind, that makes it a claim in respect of the contract, even if it is not a claim brought under the contract. No doubt some connections are more remote than others, but the present claim has a very close connection with the insurer's contract, with the miners. As the judge said, the remoteness from the contract is something that can be dealt with when the court considers whether England is the proper place for a claim under 621(2)(a. Next, my lord, can I ask you to look? Well, in fact, can I just pause there and just stepping back, what we say these cases show is that they provide direct support for Fashion House's case that its anti-suit injunction claim falls within the 3.16c gateway, because clearly the claim in the most obvious sense affects the related contract, in fact the related agreement. It's not the related contract, it's the related agreement, which is the English law facility agreement. Why? Because obviously this anti-suit injunction claim requires disputes arising under the English law facility agreement to be determined in a specific venue, only by a VIAC tribunal. So the connection, the legal effect of the claim, and indeed of the arbitration agreement and the facilities agreement, is self-evident. Now, his lordship, however, felt that in this case, held in this case, that the jurisdiction did not apply because it does not exist in what he described as a two-contract case. That was his legal analysis. And he deemed our situation to be a two-contract case because of the doctrine of separability. The two contracts, therefore, in his view, being the arbitration agreement on the one hand and the English law facility agreement, of which it was part, on the other hand. We respectfully submit that that conclusion ignores, firstly, the wide ambit of the term in respect of a contract, which we see from the cases I've taken your lordship to, including specifically Yoel, which was in the context of an ASI claim, and Alban, also in the context of an ASI claim. So just as a matter of reading the plain language of the clause, paragraph 3.16c, you can see the flaw we respectfully submit. But secondly, the judge's approach to the two-contract case was based on Lord Justice Ricks's analysis in Global 5000. You'll find a copy of Global 5000 at tab 10. So, the background to the case, very briefly, you can pick it up from the head note at 218, page 218, but I'll summarize it to you. This was a case that concerned a Jersey company that was a party to an English law purchase and sale agreement with an Indian company. And the judgment concerned Global 5000's application for permission to serve a claim out on the managing director of the Indian company. The claim against that managing director was based on a guarantee that that director was alleged to have entered into or to have given as a result of what was said by him in a letter that he wrote in support of the purchase and sale agreement while it was being negotiated. Managing director was not a party to that sale and purchase agreement. And the court held, firstly, that there was in fact no guarantee arising from the letter. And that disposed of the service out application. No arguable case in respect of which the attitude injunction, in respect of which a contract would be said to arise. However, Lord Justice, in respect of its service out could be justified or permitted. However, Lord Justice Ricks proceeded nevertheless to analyse the scope of this jurisdiction assuming that the guarantee had existed, in other words. In broad terms, he concluded that there was only a collateral connection between the putative guarantee and the sale contract, and that collateral connection was insufficient to found jurisdiction. But his detailed analysis of the two contract situation is set out in from paragraph 58 onwards, paragraph 58 through to 64. And what he said was this. Firstly, in 58, he identified 4 possible tests for the jurisdiction. First one set out by Longmore J in Greenwood. I think that should be Longmore LJ, actually, in Greenwood, which was that the claim has to have a connection with the contract, making the point that Longmore J did, that makes the claim in respect of a contract, even if it's not a claim under a contract. Remoteness and sufficiency is a matter for proper place. But that was the one, he made the point that's a one contract case. He then went on to say, it follows, it has to be shown, bottom of 227, has to be shown to the standard of a good arguable case also that the contract relied on exists and that it is governed by English law. The question, however, of whether that approach applies in the same way to a two-contract case and, this is the important point, and to a case where the contract relied on is not one to which the defendant is a party, those remained open after, notwithstanding Greenwood. So that's the first approach. The second approach, the second test, was one that was identified by Hamblin J, I think it's in Cecil Byatt, which is the pleading test of what is a sufficient connection. And that was a test that was analysed by Hamblin J in a conventional two-contract case. Cecil Byatt was a case where 3 contracts were entered into about investment or allocation of shares in a particular company. One of the 3 contracts was governed by English law. The other contracting parties tried to bring a claim under their contracts and said it related to the first contract because it's governed by English law. Traditional 2, in fact 3 contract case, reasons I'll explain in a moment, it doesn't apply here. But that was the context of Hamblin J's connection or analysis. And he said that the issue was whether or not the related contract had to be pleaded as part of the claim and whether it had to be a legal connection between the 2 contracts. That was Hamblin J's test. And Lord Justice Ricks said of this, he may be right, for intuitively, something is needed to explain why, if reliance were to be placed directly on contract A, the contract under which the claim is made, the application for permission out would fail, but might succeed if instead contract B, which is only linked in some way to contract A, is relied on for passing through the jurisdictional gateway. He then went on to say, it is not obvious to me that in this respect, a 2-contract case is different from a 1-contract case. Then at 60, there was the third test, which in fact was one that was put forward by counsel, which was dismissed, counsel in the case before Lord Justice Ricks, which was dismissed. Now it's the 2-contract case. The claimant must satisfy the good arguable test by demonstrating the existence not only of contract B, contract relied on for passing the jurisdictional gateway, but also contract A, because that is the link which takes the 2, it takes one to the other. That's the third test. And then the final test, paragraph 61, 228. The fourth test is perhaps a variation of the alternative rationale in Cecil Byatt. Question arises, in a 2-contract case, of just which contract is the contract in respect of which the claim is made. Is it contract A or is it contract B? If in truth the claim is made under or pursuant to contract A, and plainly also a claim being made in respect of contract A, can the claimant choose to say, without being gainsaid, that the claim instead being made is in respect of contract B, just because it suits him to do so, and meets a contractual jurisdiction gateway, but, and this is the second element of his analysis, but contract A very arguably does neither, so it doesn't exist, it is not governed by English law, which was the case in relation to the managing director guarantee. In my judgment, in those circumstances, no. The rule expressed in terms of in respect of and not under is intended to embrace both the standard case of claims being made under a contract and other cases of claims which are not under a contract but in respect of them. But the question nevertheless arises as to which contract A or B the claim is made in respect of in the exceptional case where the claimant wishes to bring a claim under contract A, does not wish to apply for permission to serve under contract B. But then he says this: the rationale of the rule 62 provides the answer that the relevant contract in respect of which the contract is made is contract A, and then 63, and he's obviously approaching this from a policy point of view. If it were otherwise, an application to serve out, which could not succeed if reliance were placed on the real contract which founds the claim, might be able to succeed if some mere collateral contract were relied on. That is wholly different from restitution or contribution. And then 64 is the critical part. It will be highly anomalous, his lordship said, that jurisdiction could be obtained against a defendant not within the jurisdiction by reference to a contract to, these are the relevant points, to which he was not a party, no rational basis on which a foreigner owing no allegiance to this jurisdiction can properly be brought to face trial here on the basis of a claim under a contract for whose existence there was no good arguable case, or which could not be shown to be governed by English law, merely on the basis of an allegation that if that contract had existed, there would be a collateral connection to another contract to which he is not even a party. My Lord, we respectfully submit that the context in which Lord Justice Ricks identified the two contract rule was very specific and very different, materially different to our situation. In our case, first point, there are no two contracts. This is a case involving one contract, the facilities agreement, that for narrow policy purposes, namely to support the competence principle in arbitration, is deemed to contain two agreements. So that's the first reason why Lord Justice Ricks' analysis simply doesn't apply to our case. Secondly, unlike the position in Global 5000, there is no dispute here about the validity of the related contract. The related contract being the facilities agreement. Thirdly, this is a case in which the defendant is a party to the related contract. AO, which is the defendant in question, so this doesn't apply to SBA. AO is, of course, a party to the facilities agreement. It's also obviously a party to the arbitration agreement.
So when you say the related contract, You
Sorry,
mean-
I should
you
actually
mean
say the related
contract-
agreement.
Contract, the facility agreement,
Yes.
i.e. the contract which is related to the arbitration agreement, which is the contract under which the claim is made.
Yes, we bring a claim under the arbitration agreement. It is related to the facilities contract. But I make the point again, we're not dealing with two contracts here.
But the
Two-
activity you want to stop is happening under the mortgage agreement.
Well, no, the activity we want to stop are the Moscow proceedings because we say they are in breach of the arbitration agreement.
Yeah, and they are happening under the mortgage agreement.
They have been brought before the Russian courts on the basis of the mortgage agreement, yes. But nevertheless, we say that that still constitutes a breach of the arbitration agreement. So in short, the two contract analysis of Lord Rick's context in which he identified that rule simply has no application. There's no application on the facts, and it has no application in principle. Why should the court be prevented from granting jurisdiction in order to be able to issue an anti-suit injunction case for an English law claim or English law contract, simply because the separate arbitration agreement within the same contract is now deemed to be governed by a different law. And that is entirely a departure from the approach taken by the Supreme Court in UniCredit and Risk Alliance, which your lordships will recall. The Supreme Court said it's an important policy objective for the court to support international arbitration. We'll come to UniCredit in a moment. And the legal connection, first of all, the pleading connection is made. The pleading connection of the pleading test of Hamblin J is obviously exists here because we have to plead the facilities agreement, the dispute arising under the facilities agreement, in order to prove our claim against the arbitration agreement. That's the pleading
Sorry,
test.
to go back to Ruskin, that was a claim under an English law agreement.
Yes.
Because the arbitration agreement was governed by English law, although the seat was in Paris.
That's right.
And that's why Lord Legate said
Yes.
no problem
That's right.
in assuming jurisdiction.
Yes.
Because what we're being asked to do is to enforce an English law agreement.
Your lordship's absolutely
That's
right.
different from the case we're concerned.
Yes, your lordship's right. But Lord Legate also made the broader point about how one approaches the issue of jurisdiction generally from a policy perspective, and that's what we rely on. I'll come to that in a moment.
68.
So there's a pleading connection, there's an obvious legal connection, and what absolutely cannot be said is that the arbitration agreement has a collateral connection rather to the facility agreement of which it forms part, in the way that the guarantee and the sale and purchase agreement in Global 5000 had a mere collateral connection. This isn't one of those situations.
Yes, yes. The parts of the point made us cancel 70.3.
Yeah, Mr. Simpson wants me to bring your attention to what we say in paragraph 70.3 of our skeleton, so I'll just read it out. If applied without limitation or context, VIXLJ's analysis would fail the purposive test. Why should there be a principal difference between one and two contract cases if the proper forum criterion deals adequately with remoteness and sufficiency per Longmore J in Greenwood? No need to artificially confine the plain language, emphasized both in Greenwood and in Alban. The plain language in this way, the floodgate argument is something that is swept up at the discretionary stage, not at the gateway stage. So for all those reasons, my lord, we say Mr. Justice Henshaw was, with respect, wrong to say that we were excluded from this jurisdiction by reference to the two contract principle.
Right, so that brings us to ground 3.
That brings us to ground 3. When I get to that's ground 4. No?
This is the necessary part 62. Let's go. SBA directing here.
So
Does this really run together with ground 4? Are they separate grounds?
yes, there's an awful lot of overlap. So I will take it.
Yeah. So we'll
As one.
deal with ground 3 and 4 together, will we?
I think so.
Yeah.
So, his lordship's finding about this you'll find at paragraph 78, just for your reference, page 120, and it was that the court had no jurisdiction or either under the necessary proper party gateway for 2 reasons. Firstly, conclusion that there was no real issue to be tried between Fashion House and SPA, to which therefore it will be justifiable to add AO. That conclusion was itself based on the judge's finding that the Moscow proceedings did not breach the arbitration agreement. So it's everything that we've addressed in ground 1. And but separately, the learned judge held that that it would not be just or convenient under the necessary proper party gateway to grant anti-suit injunction relief for these reasons. Firstly, he concluded that there was no reason to believe that if an injunction was granted against AO, SPA would continue the Moscow proceedings itself, or AO would ignore the anti-suit injunction on SPA's instructions. Next, that this was an overwhelmingly Russian case, so forum conveniens, Spiliada. And third, that in his view, Fashion House's likely motive for bringing the claim was to peg SPA as an anchor defendant. Now, each of those conclusions we say was wrong. Dealt obviously with the Moscow proceedings not being in breach, but the second, as far as just and convenient is concerned, that was plainly wrong because the Supreme Court in UniCredit has held directly that just and convenient is not a relevant criteria for anti-suit injunction claims. And your lordship will find that the UniCredit case is at tab 21, beginning at 524. Now we can pick it up first from the head note, and if I ask you to look, please, at the second page of the head note, page 525. And if we look at D, section D, you will see it says, it would not be appropriate to apply the test of forum non-convenience by asking whether the English court was the most suitable forum for granting an injunction to restrain breach of an arbitration agreement, since it was desirable that the parties to an arbitration agreement should be held to their contractual bargain by any court before whom they had been properly brought. Now, that if we could then if we could go please to paragraph 63. Paragraph 63, page 554.
Sorry, which paragraph?
63.
63. Yeah.
It's a conclusion on the governing law section, but it says, second sentence, it is as clear in this case as it was in Kabadji, that applying the rules of contractual interpretation of English law as the law of the forum, the parties have agreed that the arbitration agreements and the bonds are governed by English law. It follows that the Court of Appeal was correct to hold that UniCredit's claim falls within the contract gateway for service out of proceedings out of the jurisdiction. Actually, I take you to that. That's relevant to the respondent notice point, but I'll take you to that now, just for efficiency, my lord.
Well, it's relevant in that it sets the context of everything that is then said about just and convenient and what the test is set in the context of an arbitration agreement, which is governed by English law.
Well, which is
not what we have here.
No, but it goes further than that. Of course, it's particularly relevant in that case, but there is a wider point which the Supreme Court made, and you can pick it up at 68. Where it said that, and this is the broader point, where the contractually agreed forum is arbitration, the policy of securing compliance with the parties' contractual bargain is further reinforced by the strong international policy of giving effect to agreements to arbitrate. So, the seat of the arbitration was France, and the point being made there was that shouldn't make a difference, because there is a bigger objective to be achieved, and that is compliance with parties' arbitration obligations and enforcing or promoting the policy of international arbitration. That applies just as much to this to a position that we have, notwithstanding the fact that the arbitration agreement is not governed by English law. And it's picked up then at 75, page 606. In the argument in these proceedings, it has nevertheless been assumed that the Spiliada test should be applied to determine whether UniCredit's claim to enforce the contractual choice of forum may be brought in England. I do not consider that the test is apt for this purpose. That is because I do not think it right to accept that there is only one court, at most, which can properly exercise jurisdiction over a party for the purpose of preventing the party from breaking its contract to arbitrate a dispute, so that the English court should automatically decline to grant jurisdiction unless satisfied it is clearly the most suitable tribunal to do so. Rather, the appropriate point is as stated by the Court of Appeal in Enker, and in fact, a point that my Lord Justice Popplewell made in that case. In principle, it is desirable that parties should be held to their contractual bargain by any court before whom they have been or can be properly brought. So that is why forum convenience doesn't apply to an anti-suit injunction case. If the gateway is permitted and the objective is to enforce compliance with an arbitration agreement, then the English court should grant that relief, even if there is a court with a closer connection to the claim than the English courts.
Can I
That
just
is the point being made there.
try and clear my mind on what point we're on at the moment? When we were looking at Global 5000, your submission was you get through the gateway
Yes.
and the remoteness or otherwise of the connection all comes in as to whether it's proper to order
Correct.
service out.
Yes.
That's not what this is about, or,
No.
or what we're talking about when you're addressing a just and convenient argument. Ruskin assumed you were through the gateway, it was a case that was properly before the English court,
Yes.
and then was looking at whether it's just and convenient to grant the anti-suit injunction.
Yes.
To that question, Lord Legate says forum convenience isn't the right way of looking at it.
Yes.
I'm not quite sure where in your argument you address the question, which is sort of postponed by ground 2, as to whether in this case it is a proper case, assuming you get through the sufficient arguability of getting through the gateway, it's nevertheless a proper case for service out on AO. Before you get to SPA as a ground, proper case for service out on AO, where the judge held this has got precious little to do with England, it's all about Russia, and even if you're not out of court on a 2-contract claim, it is in reality a claim for breach of a contract that isn't governed by English law.
So
I raise that because I'm just not quite sure where in your argument you're going to address that. Speaking of myself, I feel that needs to be addressed.
thank you.
Would you
First
like
of all,
to
just
address that at 2 o'clock?
indeed.
2 o'clock.
Court rise in April.